Assalamualaikum, my name is Muhammad Awalin, I'm from section 44.
Okay, Assalamualaikum and good afternoon. My name is Muhammad Hafiz bin Muhammad. I'm from section 44.
My name is Nur Syafika binti Ruslan. I'm from section 44.
Assalamualaikum and good morning. My name is Azni Mirena. I'm from section 44. The objective is students need to know and understand how study or understand the law of unfair dismissal in depth. 2. Students need to know and understand what the law of unfair dismissal is in detail. 3. Students should know about the type of unfair dismissal. 4. Students should be aware for the importance of representation in unfair dismissal law codes.
Okay, first I want to present about 4 types of unfair dismissal. Firstly is relief of unfair dismissal. Second is unfair dismissal. Third is interim relief. And the last is employment-related tribunals. Okay, first types is relief of unfair dismissal. Resolving joint problems with your employer. Before, resolve the reason for your dismissal with your employer. You and your employer could try conciliation through the labor relation agency where a specialist help you sort out the problems. Okay, individual arbitration. Arbitration is in relief of unfair dismissal. Arbitration is a personal process in which the disputing party agrees that one or more individuals may decide on the dispute after receiving evidence and hearing arguments. Process is similar to a trial in which the parties make an opening statement and submit evidence to arbitrator. That's all from me. Thank you.
Unfair dismissal claim to an industry tribunal within 3 months of being dismissed can be included if a worker, member of the armed forces, self-employed person, or agency term working under a contract for service, say fisherman, member of the police service, exempt from the unfair dismissal provision by an order made by the Department for the Economy, understanding your work status, member of the police service unless you were dismissed for taking action on health and safety. Agree not to make complete if you have a compromise agreement with your employer in which you agree not to file an unfair dismissal complete, then you cannot file a complete to the industry tribunal. When you make a compromise agreement with your employer, you must get independent legal advice. If you success, industrial tribunal will be your favor. You will usually be compensated. Sometimes you will be given the opportunity to return to work. You do not have to take your job back, but your composition may be lower if not. Dalam persetujuan tidak membuat aduan, jika Anda sudah membuat perjanjian dengan majikan Anda di mana sudah bersetuju untuk tidak mengajukan aduan. Tetapi kalau ingin membuat aduan disebabkan pemecatan tidak adil, Anda mesti mendapatkan nasihat undang-undang. Jika berjaya, tribunal akan memihak kepada Anda dan Anda akan mendapatkan ganti.
Okay, hello. Next part is interim relief. What is interim relief? Interim relief is when the court grants some short-term help until a decision is made. This relief is given because quite some time can pass between when a lawsuit is filed and when the case is actually heard and decided from the court. Secondly is the help can be in the form of an asset like money to pay a bill, or it can be an order that someone cannot proceed with something until the case is over. Thirdly is, in some case, it may be able to make application to an industrial tribunal for interim relief if you have been dismissed. Fourth is, if the industrial tribunal believes it is likely at your full hearing that your complaint will be successful, it may order. Like number one is your reinstatement to work, and secondly your engagement, and thirdly is the temporary continuation of your contract of employment. The meaning of number one is that you should be treated as if you were never dismissed, and secondly is meaning that you should be re-employed but not necessarily in the same job or with the same term condition of employment, and the lastly meaning is that your contract of employment will continue until you settle your claim. Okay, next is, we can make a claim for interim relief if you believe you have been dismissed because a trade union related reason, for example like your membership. Secondly is duties as a health and safety representative, occupational pension, shame trust, or employee representative. Thirdly is made a public interest disclosure, also known as whistleblowing. And fourthly is wanted to be accompanied to a grievance or disciplinary meeting. And four, wanted to request or to discuss requesting not to retire, or you wanted to accompany to a meeting to discuss your request. And the lastly is, you should make a claim for interim relief within 7 days of being dismissed. Okay, just like that. Thank you.
Employee-related tribunal, industrial tribunal, may reduce your composition if it decides that your conduct play a part in your dismissal. The industrial court is a statutory tribunal established under the S27 of the Industrial Relations Act 1967. It was set up to hear dispute between employers and the employer over rights and obligations that arise for the employment relationship and from the provision of the Industry Relations Act 1967. Conclusion, while the agreement in preceding paragraph may possibly in regarded has somewhat tongue in check, it serves to highlight the fact that there may will be merit in researching the efficiency and balance of the current approach of the law in case on unfair dismissal. It is of course unrealistic to propose that the world monopoly of employment protection put in place since 1971 will ever be dismantled. There is force in the suggestion that the protection requirement of employee exigence employer has been extended too far.